Hello, everyone, and welcome to Uncivil Law. And for today's case, we have a very interesting freedom of speech case that results from the non-indictment related to the police shooting of Michael Brown in Ferguson, Missouri. This was a case that got quite a lot of attention at the time. A police officer shot Michael Brown, and the grand jury decided not to indict, a no true bill. And one of the grand jurors would like to talk about their experience and their vote and what other people had to say during the grand jury proceedings. But there's a catch. There's a law specifically prohibiting this because grand jury proceedings are secret. And so the grand juror is suing in order to relate their experiences as it relates to this cop murder that was not indicted in Ferguson. So this is the case of Grand Juror Doe versus the prosecuting attorney of St. Louis County, Missouri. And in this case, we're going to learn a little bit about the secrecy of grand jury proceedings and how it may or may not apply to the secrecy of this particular grand juror. Let's get started with this. On August the 9th, 2014, Darren Wilson, a former police officer within the city of Ferguson, Missouri, shot and killed Michael Brown. Following the shooting, St. Louis County prosecuting attorney Robert McCullough announced that he intended to submit the matter to the grand jury. At the time, Doe was one of the grand jurors that was serving on the side. So Grand Juror Doe was the person that was asked whether or not to indict, along with 17 of their fellow citizens, because grand juries usually have 18 or 21 people. But anyways, in Missouri, grand jury proceedings are conducted in secret. To impress upon Doe the significance of confidentiality, Missouri required Doe to take an oath of secrecy twice. Once in May of 2014 and a second time in September of 2014, swearing in relevant part that she would truly keep secret the counsel of her state, her fellows, and her own. So she's required to not talk about her grand jury experience. No member of a grand jury may declare in what matter he or she or any other member of the grand jury voted. So you can't talk about your own vote in the grand jury proceedings. And no grand juror shall disclose any evidence given before the grand jury, nor the name of any witness who appeared before them, except when lawfully required to testify as a witness in relation thereto. So a grand juror cannot talk about their own vote in a grand jury, can't talk about anyone else's vote in a grand jury, can't talk about what witnesses appeared, can't talk about what testimony occurred, because grand juries occur in secret. And so the First Amendment implications here are pretty serious, because you're precluded from your participation from talking about your experiences, which seems a little odd and a conflict with First Amendment principles. But let's read a little bit more to find out if that's true. In November of 2014, the Wilson grand jury returned a no true bill, which is to say they did not indict, and the jury was subsequently discharged. Immediately thereafter, McCullough, who was the prosecuting attorney at the time, held a press conference in which he delivered an oral statement, and in an unusual move, released some of the evidence and testimony presented to the grand jury, including transcripts, reports, interviews, and forensic evidence. So the prosecuting attorney gave a press conference after this no indictment, and as part of the press conference, released certain information that was presented to the grand jury. Now, you might wonder about McCullough's responsibility. Well, two factors. First of all, McCullough is in a different position. So they didn't have to take the same oaths. And even if they did, absolute immunity and all that stuff would still apply. So whether or not McCullough, as the prosecuting attorney, can talk about stuff, it's a wholly different question, or apparently is a wholly different question, from whether or not grand jurors can talk about literally the same stuff. So McCullough, the prosecuting attorney, is allowed to go out and say, here are some things that testify, and here's some things that were presented. And a grand juror can't contradict the prosecutor, who may be lying, not that such a thing would be ever possible. 6 weeks later, in 2014, Doe sued McCullough in his official capacity under 1983, seeking declaratory and injunctive relief because they claim the relevant laws violate the free speech clause of the First Amendment as applied to her. In her complaint, Doe alleged that she has not recounted her experience or expressed her views concerning the case on account of fears that she would face criminal penalties or contempt. She asserted that McCullough, the prosecutor, so Doe says the prosecutor, mischaracterized the views of the grand jury collectively towards the evidence the witness's credibility in the law. As a result, she sought to correct the record. So Doe anonymously is saying the prosecuting attorney may have lied or misled people about what was said and our impressions and stuff. So I'd like to talk about my experience because I have someone talking about my experience for me. I like to be able to talk about my own experience very much. But I can't because there are several laws that say I can't. So that doesn't make sense. Doe also claimed that she'd like to speak about the experiences of being a grand juror, including discrepancies she noticed in procedures utilized by the prosecution in this case compared to others, and which is typically true because typically grand juries typically sit for a period of time, so grand juries typically hear lots of different cases. It's unusual for a grand jury to be organized for a specific case. More often, they exist for a period of time and happen to hear a lot of cases. So she was a grand juror for multiple different cases, and she says, there were some things about this case that were different than the other cases I heard at the same time, and I'd like to talk about those discrepancies. Doe did not express a desire to discuss the matter publicly, completely independent of her role, but instead sought to pull back the curtain on secrecy, to discuss a wide array of previously confidential matters that go to the heart of the proceedings. So she doesn't want to discuss, she's not saying, I'd like to talk about the Wilson matter absent my role as a grand juror, which she presumably could do. So she could talk about anything that would be like in the public space. But she has some inside information. She'd like to share some information that goes beyond just talking about the matter in general. She'd like to lift the curtain, lift the veil, and talk specifically about the grand jury. So can she do that? On appeal, the grand juror, Doe, argues that the law is unconstitutional abridgment of free speech as applied, and thus the district court erred in dismissing the challenge. Missouri responds that the First Amendment free speech clause does not afford Doe a right to speak about matters she learned as part of this grand jury service. And even if the free speech clause covers her proposed speech, she waived her rights when she swore an oath of secrecy. So I guess don't swear an oath of secrecy is the object lesson of the day because you don't want to waive your rights. And also applying strict scrutiny, it's narrowly tailored to apply the interest. So you don't have First Amendment rights, you waived your First Amendment rights, and it's also, it's also restrictable under strict scrutiny. So let's figure out if any of those things are true. The Free Speech Clause of the Constitution prohibits any governmental body from restricting expression because of its message, ideas, subject matter, or content. Content-based laws, those that target speech based on communicative content, are presumptively unconstitutional and may be justified only if government proves they're narrowly tailored to serve a compelling governmental interest. So yeah, this is not time, place, manner restriction, because it's not like it wasn't that only for the period of grand jury service could you not testify, which might be a more neutral law. So not for these times, but other times. So this isn't a time, place, manner restriction because it's all times, all places, all manners. It's based on specifically the content as well. So that makes it elevated. So we have to look to strict scrutiny, which normally is borderline impossible. But let's figure out if we can do the impossible here and make strict scrutiny work. The district court held the law imposes a content-based restriction because it regulates a specific communication, and thus we assume this is correct, which it seems like it is subject-based. It is based on subject matter. You can't disclose this specific subject. Because Doe may not disclose any evidence given before the grand jury or the name of witnesses, the district court reasoned the prosecuting attorney would have to examine the content of the speech to find violations. So yeah, because you can only be held responsible for disclosing certain things. So that makes it content-based. So you couldn't do that without looking at the content. Right. It's not like you talked about it in an improper time. It's based on what you said. Accordingly, we must determine whether it's narrowly tailored to achieve a compelling governmental interest, and we conclude it is. So this is where I think the Court of Appeals are going to have a split of opinion. The Court of Appeals finds that this passes strict scrutiny, and I am less sold on that. I think that there might be certain times, certain places, while the grand jury is sitting, for example, yes, maybe even to some aspects of what the grand jury does, yes. So maybe you can't talk about specific witnesses. Maybe even like a law that says you can't talk about what other specific grand jurors voted on, or like talk about that. So maybe there are some things here that can pass strict scrutiny. The question is, to me, whether or not all of it passes strict scrutiny, because to be narrowly tailored, it has to be narrowly tailored. So is there a compelling governmental interest? Probably. Is it narrowly tailored? Well, the question is, can we think of a law that would be more narrowly tailored? And for me, the answer is yes. I think that you can't get as far as the Court of Appeals does. If you want to say that you can't talk about what other you can't reveal the names of other grand jurors, okay, because they were provided secrecy, so you can't talk about that. That makes sense. You can't talk about what specific other grand jurors voted on. They were entitled to secrecy, so that makes sense. But you can't talk about your own experiences. You can't talk about like what the prosecutor did, particularly when the prosecutor is able to talk in public. So the prosecutor is able to say, "Well, here's things I did," and you say, "No, I can't. You can't contradict that." So I feel like, yeah, me and the Court of Appeals are going to have a split here. The court says this passes strict scrutiny, and I'm like, nah, I don't think all of it does. But my opinion is not necessarily the law. The law is apparently you can restrict this grand juror from talking about all of it forever. I don't know, man. I don't know. Feels like it goes a little far from my taste. But let's read on. Let's learn about the history of grand jurors and grand juries. The grand jury is an ancient institution with roots stretching as deep as the 12th century. The early version of the grand jury was decidedly a tool of the English crown. It had two main functions: to ferret out criminals to crown officials and to extend the central government throughout England. And the crown successfully controlled the grand jury by finding its members if they failed to indict any suspect, or even failed to indict an acceptable number of suspects. So the grand jury starts out as a quota system. Just arrest and charge people. So that's how the grand jury started in the 12th century. Not great. In time, however, the grand jury gained a degree of independence, and by the 14th century, the grand inquest was no longer required to be made known to the court the evidence upon which they acted, but instead was sworn to keep proceedings secret by oath, which contained no reservation in favor of government. So initially, this was just a thing for the crown to find people to charge. And they didn't charge enough people, then the grand jurors themselves would be indicted and charged. Great. But fortunately, within 200 years, that had changed, and the evidence is to be kept secret even from the government. Well, the problem is now the government knows exactly what the evidence is because they're the ones presenting to the grand jury. So at this period in time, in the 14th century, grand juries were independent from prosecutors. But not as much now, so yeah, I don't know, man. When the institution of the grand jury came across from England to America, the rule of secrecy came with it. The framers later included the grand jury clause in the Fifth Amendment, making grand jury secrecy an implicit part of American criminal procedure, but only on a federal level because it has been specifically not incorporated by the U.S. Supreme Court. So it was an implicit part of American criminal procedure, except for, not, because it doesn't have to be. States can use them, but they're not constitutionally required, at least at the federal level. So, yeah, I don't know about that either. For example, in 1917, a court, which is the District Court of Rhode Island, which we're going to quote as an authoritative source, I guess, the District Court of Rhode Island in 1917 said a court explained that secrecy was essential because undermined justice by warning offenders to escape, to destroy evidence, or target with witnesses, which presumably the logic of that only applies as long as the grand jury is sitting. Once they're no longer sitting, that no longer makes any sense. The court also explained that secrecy protected the reputations of unindicted accused and encouraged the candor of witnesses, which, okay, that kind of makes sense. But again, if we need to write a law that deals with this, we could constrain it further. So if our concern is we don't want to talk about people who are unindicted who appeared or witnesses because it's that their need for secrecy, yeah, that might pass strict scrutiny, at least in this humble jurist's opinion. But to prevent you from talking about your own experiences or things the prosecution experienced, I don't know, man. Seems like it goes too far. These justifications have been widely accepted by American courts as validating the rule of grand jury secrecy. In general, probably true. But when we're applying First Amendment analysis, we need to look for something that's the least restrictive means, and I don't know that we're there. We have previously explained that what constitutes a compelling interest is not easily defined, which is fair enough, but we've recognized the state advances a compelling interest when policy is necessary for upholding justice. That is because administration of justice is an interest of the highest order and an overriding state interest. Sure, okay. Also, it was mentioned in the U.S. Constitution, so that kind of makes it important. So I'll give with you there. The Supreme Court has frequently observed that secrecy ensures a grand jury fulfills its dual function as both a sword and shield of American law, ferreting out crimes deserving of prosecution and screening out charges not warranting prosecution. But since the prosecutor is the one that decides what evidence to present and how, the ability of the grand jury to do that is kind of somewhat not as strong as you seem to be implying in this language. Missouri maintains an interest in protecting the secrecy of grand jury's deliberative process. Again, if you wanted to go specifically to the deliberative process, which is to say the process of actually deciding whether or not to indict, then that might make sense, but again, the law is not that narrow. McCullough, the prosecutor, did not reveal any information regarding the jury's membership, deliberations, or voting, because they weren't present during the deliberation and voting. The prosecution isn't there for that. And yeah, they didn't name any names of the grand jurors, so sure. And we believe they maintain an interest in keeping this information, including Doe's own views, secret. Yeah, no, that I don't know that I can get behind. You have an interest in keeping Doe's own views secret. It's her views. If she wants to share her own views, then how can the state's interest get that far? Like, other people have an interest in their views, okay, but she has an interest in her own views, and we can get that past strict scrutiny as a least restrictive means. I'm not really 100% sold. And it does not suffice to say that grand jurors could respond to criticism, because permitting them to respond would have its own adverse effects, including the subjection of grand jurors to a degree of press attention and public prominence that might, in long term, deter citizens from fearless performance of the grand jury service. I don't understand how any of this works, because it doesn't work in a petite jury, otherwise known as the jury that you know and love from like every cop show ever. So the grand jury that you all know and love from criminal trials, the 12-person jury, the one that says guilty or not guilty, that's otherwise known as a petite jury. Petite jurors can talk to the press after their service. They do all the time. So petite jurors can talk about their own service, and again, their ability to talk might be somewhat constrained. They typically do not talk about what other specific jurors voted on. They typically do not reveal other specific jurors by name. But petite jurors, which is to say people who pass the ultimate sentence of guilt, they can talk about their jury experience. They can talk about their vote or not, and it hasn't been a problem. Like, everyone knows that jurors can or cannot, and in really big trials, the court will usually go to the effort of making a point of saying to the jurors as they're being dismissed, you have the right to talk to the press or not, and you have the right to talk to the defense lawyers or the prosecution lawyers or not. And they'll make a point of saying no one can force you to talk to them except through a court order. So if the prosecution knocks on your door and says, why didn't you vote guilty in this? You can tell them to buzz off. And they can't force you to testify. And if they try to force you, you can come to the court and I will whack them over the head with this really big hammer I have in my hand right now. I will whack them over the head because they can't force you. And if the defense wants to come and say, why did you vote to convict my guy? You can tell them to buzz off. And if they try to force him, again, you can drag the defense lawyer before this court and I will whack them over the head with this really big hammer I have in my hand right now. And if you choose to talk to them, you can, or not, to any degree you want. And you can choose to stop talking or not answer any question. And if you want to talk to the press, you can, or not. And also, you can stop talking to them if you want, and you cannot answer any question you want. It's totally your call. Right? So you may have seen this from really big trials, because you may have seen the judge give these instructions. In really big trials, they'll make a point of it. It's like, and also, please respect your other jurors' privacy is usually a thing they will say, because they have a right to make the same decision you have the right to make or not. So why would it deter people from grand jury service when it hasn't deterred people from petite jury service? The petite jury can talk about their experiences and why they made the decisions they made, and can talk about the deliberative process if they want or not. So, like, why would it be a massive problem in a grand jury if it's not a massive problem in a petite jury? Why would it suddenly be a massive imposition if grand jurors could talk about their experience? I don't know. The court seems to think it would be a massive problem. They seem to think the world would come to an end if grand jurors could talk about their experience, because the world has come to an end because petite jurors can talk about their experience. What? I don't understand. This doesn't make sense to me. Next, we do not believe the challenge provision sweeps too broadly. I and the Court of Appeals have a difference of opinion. I think it does sweep too broadly. Why can Doe not talk about her own experience and her own impressions, even if she can't mention other jurors by name, or even if she can't reveal like specific witnesses who appeared? Like it does sweep too broadly. Me and the Court of Appeals have a beef, man. Doe does not claim she's prevented from discussing anything concerning the matter other than the knowledge she gained of evidence, witness identities, and deliberation in the context of her role as a grand juror. So she can talk about things that are in the public domain. Yeah, but she can't talk about being on a grand jury and what it's like. And her own impressions of how the prosecution presented evidence and stuff. The requirement that Doe does not disclose matters she learned as a grand jury is a limitation on speech that's narrowly drawn to protect these interests heightened above. Not narrow enough in this jurist's opinion. Not narrow enough in this jurist's opinion. Finally, we conclude there is no more limited means by which Missouri can advance its interests. What? Yes, there is. I've been describing some for a little bit now. There are definitely more limited means that would if we have an interest in keeping witnesses secret at a grand jury, which maybe we do, because it's kind of like more like a police investigation. So maybe witnesses should be secret at a grand jury. So maybe we shouldn't be able to disclose specific witnesses. Okay, maybe we shouldn't be able to disclose other grand jurors who were there. Should that prevent you from disclosing your own experience or what it was like or the prosecution and what they did? I mean, everyone knows the prosecution was there, so we're not revealing anything. Of course the prosecution was there. Should we be able to prevent from comparing and contrasting? I think there are more narrow ways to do this. If Doe were to speak about the quality of the evidence, the credibility of witnesses, or deliberation, she would necessarily undermine the function of the grand jury. Witnesses in future cases may be less candid. How do you come to that conclusion when jurors in petite juries do this all the time and no one thinks that petite juries have been undermined? How do you come to the conclusion that witnesses in grand juries would be intimidated and less candid when they're not intimidated and less candid before petite jurors, because petite jurors can testify or can give their experience even if grand jurors can't? How are you coming to this conclusion in light of the experience of petite juries? This doesn't make sense to me. The Supreme Court's holding is not contrary. There, held a witness who testified before a grand jury could not be prohibited from disclosing the substance of his testimony after the term of the grand jury had ended. So the Supreme Court said a witness cannot be prevented from disclosing what he disclosed after the term, which again makes it a more narrow restriction. So you can be prohibited from disclosing while the grand jury is still sitting, but not afterwards. Okay, I mean, that kind of makes sense, but it's a time, place, manner restriction, so like not as long as the grand jury is sitting, but it's not indefinite. But this is indefinite. So if the witness can talk about their experiences without compromising the sanctity of the grand jury, why can't a grand juror? The court purposely did not address the right of witnesses to discuss their experience before the grand jury. It instead limits holding to allow witnesses to divulge information of which they're in possession before they testified, and not information which they may have obtained during their participation, which I don't even know what that is. Because before a grand jury there's only the one lawyer, the prosecution. So what information would you gain as a result of a grand jury? I don't know. I mean, maybe the names of the grand jurors or like the composition of the grand jury. So yeah, you can be prohibited from talking about that, I guess, but like who, whatever. It's like there were this many men and this many women, and really that's like a huge secret. What else are you learning about from the grand jury? I don't even know. It doesn't even make sense. Okay. Accordingly, we hold, as applied to Doe, the Missouri revised statute is narrowly tailored to serve these interests. As accordingly, this is a rare case that survives strict scrutiny. I don't know, man. I cannot get on board with this one from the Court of Appeals, which apparently was a unanimous decision. So I disagree. I disagree with 3 federal judges. Yeah, me and 3 federal judges have come to a different conclusion. What can you say except me and 3 federal judges came to a different conclusion? I don't know. I disagreed with the Supreme Court in Kansas v. Glover. I disagreed with 8 members of the U.S. Supreme Court in Kansas v. Glover. I disagreed with 8 sitting justices. so, so, okay, I think I got this one wrong. Oh well. So that is the end of our coverage of the United States Court of Appeals for the 8th Circuit's case in Grand Jurors versus the prosecuting attorney of St. Louis County, Missouri. So, yeah, I disagree with 3 sitting federal judges. This was a unanimous opinion, 3-0 from the United States Court of Appeals. So I disagree with 3 sitting federal judges. So I don't know what to tell you except to say we come to a different conclusion. I think that maybe some of this passes strict scrutiny, but it is overbroad. It cannot possibly be correct in this humble jurist's opinion that you can't prevent a person from talking about their own experiences. You want to prevent them from talking about other people that were there to protect privacy. Like, okay, but why can't they talk about their own experiences or what the prosecution talks? And why is it such a big deal when petite jurors do it all the time, and it hasn't undermined the sanctity of the criminal justice system? If petite jurors can talk about their experiences and the witnesses they saw and stuff and things, why will it be the massive end of the world for grand jurors to do about it? I mean, grand jurors are more of a police process, so there is more of an implication of secrecy. I understand that. So the logic doesn't completely track, but it also doesn't completely not track. So if it hasn't come to an end, like, can we think of a more narrowly tailored law than the one we have? I can. So, yeah, me and the Court of Appeals just disagree. Unfortunately, I don't really see this going to the U.S. Supreme Court. I don't really see any appetite for the U.S. Supreme Court to get involved. So, short of a miracle, that is the end of the coverage of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.